The case before us today concerns a laparoscopic colectomy that was performed by Dr. Ward on Miss Armstrong, and the reason for the surgical process was to remove her colon. So during the surgical process, the appellant sustained injuries, and more specifically, her ureter was injured. So this injury in turn resulted in Miss Armstrong also having to get her kidney removed as well. At the trial level, Justice Mulligan concluded that Dr. Ward produced the injury to Miss Armstrong's ureter, and that by doing this, he breached the standard of care that was expected of him as a reasonable and prudent surgeon. The decision was reversed at the Ontario Court of Appeal. The majority held that the trial judge's analysis was incorrect in multiple ways, all of which I will subsequently discuss for you. So there are four main issues that we will be addressing today. And these issues fall under two subsequent categories, both standard of care as well as standard of review. So in regards to standard of care, first we need to determine what the requisite standard of care for medical negligence in Canada is. And in addition to this, we also need to determine how it can be applied to the particular circumstances of this case. Second, we need to identify whether causation can or ought to ever be used as circumstantial evidence in order to inform the standard of care in medical negligence cases in Canada. And third, we need to examine the evidentiary burden on the plaintiff. And in doing this, we need to determine whether the plaintiff has a duty to rule out non-negligent causes. And fourth, with regards to the standard of review, we need to determine whether the majority at Ontario Court of Appeal erred in applying a correctness standard of review. Today, the appellant submits four main arguments, each of which I will go into detail for you shortly. In his understanding of the standard of care as it applies to the particular circumstances of this case. The judge concluded that a reasonably prudent surgeon would have stayed 2 millimeters away from Miss Armstrong's ureter. This was a correct finding and was in fact supported by expert evidence, which I will go into again shortly. Second, while there is a general principle or consensus in Canada that the standard of care should be determined prior to engaging in any discussion of causation or any analysis of causation, prior jurisprudence has actually established that there are certain instances, such as Miss Armstrong's case, where causation can effectively inform the standard of care. Third, with regards to the evidentiary burden, the burden of proof should fall on the defendant in ruling out non-negligent causes. And the reason for this is because it is their professional background that actually renders them capable of eliminating any other possibilities for medical errors. And ultimately, in terms of the issue of the standard of review, we argue that the majority at the Ontario Court of Appeal erred in applying a correctness standard of review. The first issue on appeal that I will be addressing is with regards to what the requisite standard of care for medical negligence in Canada is, as well as how it is applicable to our case. So the appellant advances the following point. The trial judge did not err in his understanding of the standard of care in this particular case. Our objective here is to essentially show the court why the trial judge was correct in concluding that a reasonably prudent surgeon would have stayed 2 millimeters away from Miss Armstrong's ureter. So I would just like to take a brief moment to return to the reasoning of both the trial judge and the appeal court. The trial judge determined that Dr. Ward did not take reasonable care and that he breached the standard of care that was expected of him by using the ligature tool within 2 millimeters of Miss Armstrong's ureter. The Court of Appeal disputed this finding, and they instead found that the trial judge erred in his standard of care analysis by inspecting Dr. Ward's actions through a standard of perfection, I believe that was the word that was referenced, rather than a standard of reasonable care. So more specifically, the court stated that ensuring not to bring the ligature within 2 millimeters of the ureter should not have been considered a step just because it created a standard that was simply too high. This is incorrect, and I will explain why. So in Critz versus Sylvester, the Supreme Court of Canada established that medical professionals in Canada must approach their tasks with both a reasonable degree of care and knowledge. Similarly, in Terneuzen versus Korn, the court mentioned that a medical professional's work will be measured against the standard of a capable and prudent practitioner that is in the same field with similar experience. So I should just note for you that specialists such as Dr. Ward are to be measured against the standard of practitioners within that specific field of practice. Taking these cases into consideration, we can see that, at least in Canada, the standard of care that applies to Dr. Ward should be an inquiry as to how a reasonable practitioner in the same field with the same standing and experience would have addressed the procedure. And as we know from expert evidence provided at the trial, the witnesses unanimously agreed on the importance of identifying and protecting the ureter during a laparoscopic surgery. So in other words, all of the medical experts at the trial agreed on the point that not coming into contact with the ureter is a central aspect of the surgical process. The main point of disagreement, however, was with regards to Ms. Armstrong's ureter and how it was injured, as well as whether bringing the ligature tool within 2 millimeters of the ureter would have meant that Dr. Ward was breaching the standard of care. My co-counsel and I argue that their test.
Sorry, just to. Oh, I'll let Justice Michael go.
Okay, thank you. The defendant maintains that he kept or took reasonable care to stay away from the ureter by maintaining that distance. Was the only evidence the fact of the injury that he failed to maintain that distance?
I'm so sorry, I apologize. Do you mind repeating your question?
Was the only evidence that he failed to maintain the requisite distance from the ureter the fact that the injury occurred?
So I believe it was shown that there was actually a burn on the ureter, and that was the main piece of evidence that they were looking at, if I'm correct.
So in order for the injury to have occurred, he must necessarily have come within
exactly
2 millimeters of the ureter.
Yes, correct. So at the trial level, the trial judge demonstrated that, as well as the expert evidence, it showed that with the ligature and the specific surgery, that the surgical process that occurred, the only event that could have been, or the only cause that could have been predicted, was that the ligature did come within 2 millimeters of the ureter.
Thank you.
Thank you. I hope that answers the question. So my co-counsel and I argue that the testimony of the expert evidence essentially affirms that the standard of care for a reasonable surgeon performing a laparoscopic colectomy is met by identifying and protecting the ureter and ensuring that the ligature does stay a safe distance away from that area. So I just want to emphasize this point by saying that the minimum standard of care that we are establishing here is not only trying to avoid the ureter, but actually staying away from the ureter as well. So the second issue that I would also like to bring the court's attention to is the following question. Does Canadian law regarding medical negligence permit causation to be used as circumstantial evidence in order to inform the standard of care? In responding to this issue, the appellant takes the position that the general legal principle in Canada is that the standard of care should be determined prior to engaging in any analysis of causation. However, there are specific instances, such as this one, where the cause of the injury can actually effectively inform the standard of care. In these instances, it is necessary to first look at causation in order to be able to determine if the standard of care was actually breached. The trial judge held that Dr. Ward breached the standard of care expected of him as a reasonably and prudent surgeon, and that it was specifically his negligence that resulted in Ms. Armstrong's ureter injury. The Ontario Court of Appeal disputed this finding and found that the trial judge's analysis was incorrect. And the reason that they gave for this was because it examined the cause of Ms. Armstrong's injuries prior to establishing the standard of care. This is also incorrect, and allow me to explain why. So it is true that generally the standard of care should be identified prior to engaging in a discussion of causation. However, so we saw this in cases such as Bafaro versus Dode, and the court affirmed that standard of care and causation are two different areas and they each require separate consideration and attention. However, despite these rulings, the court has allowed for certain instances that require a finding of injury prior to standard of care. It's important for me to note that in these particular moments, causation can actually be effective in informing the standard of care. So as a point of reference, we see this come out in cases such as Kennedy versus Jack Weowicz, as well as Grass versus Women's College Hospital. And both of these cases are fundamental because they confirmed that there are exceptions to the general rule and that it can be, based on the particular circumstances of a specific case, effective sometimes and even necessary to examine causation in order to inform and understand the standard of care. So with consideration—
Counsel, sorry to interrupt, but how is one to determine in which situation it's appropriate to look at essentially the result of the surgery before you engage in your standard of care analysis? So in this case, I appreciate your argument is that this is an appropriate case, but how are we to determine what cases are appropriate and why does this fall into that category?
Yes, so I believe that one of the main factors that need to be taken into consideration is the complexity of the case. So in this specific case, one of the fundamental issues was that the camera that was being used during the surgical process was not, the ureter was not in the view of the camera. And so the only way we can actually fully gain an understanding of how the injury occurred is through inference. And in order to do that, we need to use circumstantial evidence in order for that to inform our understanding.
Thank you.
No problem. Thank you. So with consideration to these rulings, Ms. Armstrong's case can be understood through a similar lens. So for individuals such as Ms. Armstrong, causation can inform the standard of care expected of their doctor. And the trial judge at the trial level considered two separate possibilities that would inform his understanding of the events that occurred. So he noted that Dr. Ward used the ligature within 2 millimeters of Ms. Armstrong's ureter, or instead that he remained 5 to 15 centimeters away, which is a statement that was said by Dr. Ward at trial. So we know that the ureter was not in the view of the camera during the surgical process. This means that it was not visible how the injury occurred. And for this reason, causation, so the injury and how it did occur, can only really be inferred through circumstantial evidence. This means that it becomes necessary for the trial judge to rely on circumstantial evidence, which would include the nature of the injury as well as how it occurred. And this is necessary in order to determine the standard of care. Thank you very much.
Perfect. I believe this is where I jump in. I'm not sure if I should wait for my cue or if I should go ahead and tackle the remainder of this, but my co-counsel did an excellent job of setting us up for the third topic that needs to be addressed with respect to the standard of care inquiry. So with respect to the standard of care inquiry, it is It should be noted that it is the plaintiff's role in ruling out non-negligent causes and providing supporting evidence. As mentioned at the Ontario Court of Appeal, if a trial judge wishes to establish negligence as the sole cause of injury, then they must consider and dismiss all other non-negligent causes. With respect to the Court of Appeal's determination regarding the dismissal of non-negligent causes, my co-counsel and I would like to consider this final standard of care issue. Does the burden of proof regarding non-negligent causes in this case fall on the shoulders of Mrs. Armstrong? Upon this appeal, Mrs. Armstrong submits the following argument regarding the law on the burden of proof and the plaintiff's role in ruling out the non-negligent causes of an injury. The burden of proof should fall on the defendant given their professional background that renders them capable of eliminating other possibilities for medical errors. Presently, there is a body of law that supports the notion that some situations do allow for the defendant to rebut the presumption of negligence by providing evidence if it exists. So a notable case to reference in this situation would be that of Snell versus Farrell. The court suggested that in situations that require a standard of care to be established or for the defendant to discharge their duty of care, it is the defendant's responsibility to provide evidence that rebuts the presumption. Specifically in this case, Justice Sapinka asserted two principles in regards to the assignment of the legal burden of proof. He notes that although the initial onus does fall on the plaintiff because they are the individual advancing the claim, if the topic of inquiry concerns specialized information that one party is privy to, the onus may fall onto the party that is most knowledgeable under the circumstances. The ruling in Cooper versus Dr. Flood also further supports this notion, as the court in this case established that once the only possible cause of the plaintiff's injury is determined to be from negligence, the evidentiary burden shifts to the defendant to challenge the finding. To provide some context, Cooper was a medical negligence case addressed at the Alberta Court of Appeal, where the defendant was a surgeon that was unable to provide non-negligent reasons for the plaintiff's injuries. When addressed by the court, the defendant did not provide evidence for other non-negligent causes, which ultimately left the court with negligence as the only plausible explanation. I believe for good measure, it's also worth noting the ruling in Austin versus Bubella, which reaffirmed that the burden of proof necessary to prove a breach of the standard of care falls onto the plaintiff unless the burden can be discharged with circumstantial evidence that results in an inference of negligence to be drawn. When this inference can be made, it becomes the defendant's responsibility to provide an explanation that negates the assumption. So, with respect to these rulings, we believe a similar course of action can be applied in the case of Ms. Armstrong and Dr. Ward. It should be noted that thus far, Ms. Armstrong has presented evidence supported by expert testimony that establishes her prima facie claim. And so, in accordance with the case law, the burden must accordingly shift to Dr. Ward to present non-negligent causes for the injury in his defense. And I must note that although the case law bears weight in this situation, so does common sense and an understanding of medical capacity. Dr. Ward was the only individual present in the operating room while Ms. Armstrong was anesthetized. Any gaps in the narratives or potential explanations for the cause of our client's injury would best be explained by the medical professional who prescribed, moderated, and conducted the procedure. Given Dr. Ward's background, knowledge, and key role in the surgery, he is evidently the most suitable and capable witness to attest to the events that ensued. Placing the burden of proof on the plaintiff's shoulders in a medical malpractice case confers an unreasonable standard for clients with likely a limited understanding of human anatomy and medicine. This really does raise a question of ethics. How is it that, yes.
Sorry to interrupt, but the plaintiff, Ms. Armstrong, in this case had a number of experts review the records and provide opinions on her behalf. I appreciate your position is that she is not a medical professional, but she has retained medical professionals to provide opinions on this case who most certainly have enough experience to opine on potential causes of injuries and what occurred during the procedure. So how is she prejudiced in any way because she's being advised by these qualified medical practitioners?
I didn't necessarily, sorry if I'm misunderstanding your question, but in regards to the prejudice aspect, I believe that most of the expert testimony was supporting of the fact that it was the fault of the ureter in regards to, like, it somehow came within 2 millimeters, but for the 2 millimeter ligature. Yep, sorry.
So your submissions were that it's not fair for the plaintiff to have to rule out non-negligent causes, but she has experts that are advising her that are well qualified and experienced in this type of procedure. Why shouldn't they have to give evidence on the ruling out non-negligent causes?
Well, if I'm correct, I believe that our expert witnesses did provide a number of reasons as to how this was an instance of negligence. But not only that, realistically speaking, it was Dr. Ward in the surgery room that would be able to attest to, for example, a nurse's arm being bumped, a shake in the room, something that would have caused the injury. Sometimes expert evidence can only provide so much. And in this case, the expert evidence did support the fact that the ligature seemingly came within 2 millimeters of her ureter, and any other evidence that could be presented would have to be on the shoulders of Dr. Ward.
Thank you, counsel.
Thank you.
And just to follow up on that, counsel, did he not sufficiently demonstrate that he took all of the reasonable steps that a prudent surgeon would have taken in similar situations, that he did in fact do everything that was needed in order to protect the ureter?
I do believe that he made the statement that he identified and protected the ureter. Those were the two steps that he listed, but he didn't necessarily list the third step, which was to stay 2 millimeters away from the ureter, which one of our expert witnesses did note. I believe that Dr. Burns, I'm sorry, his name is evading me at the moment, but one of our strongest expert witnesses noted that it is reasonably common knowledge not to allow the 2 millimeter the ligature to come in contact within 2 millimeters. It was a seemingly standard perception of the tool.
And is it your position that there can never be a situation in which that allows for room of error? So there's no reason that he could have come within the 2 millimeters in a way that was not negligent?
You see, understandably, in the medical field, there's always going to be a risk, especially when you're undergoing a surgery. But at the same time, the hesitations that arise with Dr. Ward's case was when he was providing evidence, he noted that he either was 10 to 15 centimeters away or 2 millimeters away. And that's quite a drastic jump. Those are two numbers that are very difficult to conflate. And so his almost indecision was what caused concern for my co-counsel and I. It just seems like any reasonable surgeon would know the difference between whether he stayed 10 to 15 centimeters away or whether it was 2 millimeters away.
Sorry, counsel, is that in the evidence that a reasonable surgeon would know the difference in the circumstances of the surgery?
Oh, and the difference between 10 to 15 millimeters versus 2?
Yeah, so my understanding of the procedure is it's done laparoscopically and the surgical view is obtained through a camera. So it's not, I mean, that limits your surgical view. So does the evidentiary record support your statement that a reasonable surgeon in the circumstances would know the difference between 5 millimeters and 10 millimeters?
There wasn't information on our behalf that indicated the difference, but I just assumed common knowledge that it would be quite simple to differentiate between those two hefty distances. But no, to answer your question, no, unfortunately, that was not listed in our evidence. If there's any further questions, all right, I will proceed with the remaining point on that note. Ultimately, I guess just to kind of wrap all of our questions in one, I should note that Ms. Armstrong, although she did have expert witnesses supporting her, she was at the end of the day incapacitated. She was unable to attest to what happened in the surgery. And on that note, we can move on to the final issue, which would be standard of review, where it must be considered whether the majority erred in applying a correctness standard of review. My co-counsel and I respectfully disagree with the Court of Appeals application of a correctness standard of review. Based on our understanding of the facts, it seems as if the Court of Appeal usurped the power of the trial judge by disputing his findings of fact and evidentiary conclusions. As a rule of law, the drawing of evidentiary conclusions and determinations of fact are within the trial judge's jurisdiction. The appropriate standard of care the appropriate standard of review would have encompassed the argument proposed by Justice Van Rensburg, who wrote the Court of Appeals dissenting opinion. In her statement, she affirmed the importance of paying deference to the trial judge on all findings other than questions of law. We believe that her assertion was valid as it acknowledged the determinations made by the trial judge were correct, available, and fully supported by expert evidence. With respect to the majority decision, it seems apparent the court did not award due deference to the trial judge and displayed preference for certain expert opinions over others. Ultimately, the appellant, Ms. Armstrong, requests two fundamental orders. First, that the court restores the findings and judgments of the trial judge, and second, that the costs are granted for her application. Ultimately, the evidence that my co-counsel and I have presented to the court today critically analyzes the four issues pertaining to the standard of care and the standard of review. Your Honor, we wish to conclude by affirming the magnitude of this case, not just on the life of Ms. Armstrong, who has lost her kidney, but on individuals who encounter medical practitioners and undergo life-altering surgeries. The reality remains that surgery is an integral part of our lives, and it is indefinitely a process that fuses trust, expertise, and professionalism. Moving forward, we must be mindful of the implications that may arise if analyses are too stringent and too rigid to allow for reality to seep through. Transparency within the medical field is essential, and I hope that moving forward, my client is able to move forward knowing that her loss will not have to be anyone else's. Thank you.
The court now invites counsel for the respondents to begin.
Before we go on, I think we've lost Madam Justice Crocker, so don't know if proper protocol in moot court suggests we wait, but don't know if we should give her a minute.
We can wait a minute, no problem. We usually wait about 5 minutes, and if not, we can proceed with that.
By my time, she's only been gone for about 30 seconds, so I'm not sure if it's a connection issue.
The court now invites the respondent's counsel to proceed.
Good morning, Justices of the Court. My name is Veronica Attia, and I, along with my co-counsel Tess Chambers, represent the respondent, Dr. Colin Ward. I will begin by addressing the error in defining the standard of care as the absence of injury, followed by discussing the standard of review. My co-counsel will then address Dr. Hagan's testimony, the problem with conflating causation with the standard of care analysis, and the issue with the plaintiff not ruling out non-negligent causes. In February 2010, Dr. Ward performed a colectomy on Miss Armstrong. He did so laparoscopically rather than using the traditional open method. The issue before this court is whether or not the Court of Appeal erred in reversing the trial judge's decision and concluding that Dr. Ward did not negligently perform the colectomy on Miss Armstrong. Your Honors, this is a case of a surgeon performing a procedure with a known risk. Steps were taken to reasonably perform the surgery, and despite Dr. Ward's best efforts, an injury still occurred. This leads me to my first argument. The trial judge defined the standard of care as the absence of injury. This is incorrect for two reasons. First, defining the standard of care by an outcome rather than the steps taken to achieve that outcome imposes a standard of perfection. Second, the cause of an injury is irrelevant to a negligence analysis if the standard of care was met. Defining the cause of injury as the standard of care leads to circular reasoning. My co-counsel will address this second issue later, but to address the first issue, the absence of injury is not requisite to the standard of care for medical negligence. The standard of care asks whether the defendant behaved as a reasonable and prudent person would, given the same circumstances. The Supreme Court in St. John and Mercier sets the standard against a retrospective analysis in reasoning, considering whether a specific act or omission to act constitutes fault leads to an analysis based on results rather than means. Instead, we should ask whether a reasonable, prudent professional would have taken those steps. To take a results-based approach and conclude that avoiding injury is the standard of care is incorrect, as it imposes a standard of perfection rather than a standard of reasonableness. A surgeon is expected to have a high degree of knowledge and skill, and therefore owes a duty to their patient to use diligence and caution. The law holds surgeons accountable to a reasonable degree of care, but the standard of care does not guarantee results or require perfection. The trial judge erred in concluding that an injury constituted the breach of the standard of care, because the standard of care cannot be based on absolutes. He defined the standard of care as identifying and protecting the ureter and avoiding close proximity or direct contact with the ureter. The trial judge therefore defined an injury as the breach of the standard of care. Such a definition of the standard of care is inconsistent with the jurisprudence, as I have noted in my submission, which emphasizes a reasonable standard rather than a standard of perfection.
I'm sorry to interrupt.
Sorry.
Oh, please go ahead.
I was just going to say, was it truly a standard of perfection to avoid injury, or rather to avoid coming within 2 millimeters of the ureter?
So they defined the standard of care as not coming within 1 to 2 millimeters of the ureter, but their experts note that coming within 1 to 2 millimeters guarantees an injury. And that's what they're saying the breach is. They're saying you've breached the standard of care by coming within 1 to 2 millimeters, but if you come 1 to 2 millimeters, 100% an injury will occur. So in defining the standard of care in that way, it's synonymous to say that 1 to 2 millimeters and avoid injury. It's the same thing, because if you come 1 to 2 millimeters, you're guaranteed to cause an injury. So in that sense, they're defining the standard of care as avoiding injury. And the only way to not breach that standard of care, to meet the standard of care, is to avoid injury. What I'm saying is that they should take, the standard of care is about the steps that need to be taken to avoid the injury, not whether or not the injury itself occurred.
Yes, counsel, but as we heard from your friends, wasn't it also a case that, sorry, apologies, I saw that Justice Michael wanted to jump in as well.
Please continue your questioning.
Sorry, my question was, didn't we hear evidence from your friends that a reasonably prudent doctor would never have come within 1 millimeter or 2 millimeters, that in fact, there was a likely close to 0% chance that anybody else, any other surgeon wouldn't have made this mistake as a vital step in such a procedure?
So I will address more in just a second on that issue of distance of the 1 to 2 millimeters. But to answer your question, there is a risk in any surgery that an injury could occur even when the steps are taken. And my second point is that the step taken is not just to avoid 1 to 2 millimeters, but it's also to identify and protect the ureter. And this is something my friends have also noted that all of the medical experts agree to, that the identifying and protecting the ureter is what's important to avoid injury. So the trial judge did accept that Dr. Ward correctly identified and protected the ureter. And in fact, in Dr. Hagen's testimony, he explains in detail the process of separating the mesentery and removing the ureter outside of the view of the camera so that they can work on the colon. So my friends actually noted the issue of the ureter not being in the camera. How would we know then that the ureter wasn't touched? And Dr. Hagen actually notes that if Dr. Ward correctly identified the ureter, he would be approximately 3 to 4 centimeters away from the ureter. And the trial judge confirms, the trial judge accepted that Dr. Ward did identify the ureter correctly. So this should be evidence that Dr. Ward did keep the distance away from the ureter. Does that answer your question? Yeah.
So I just wanted you to clarify what you say the standard of care was that the judge applied. We know the legal standard is for the surgeon to take reasonable care.
Yes.
I thought you said that the judge said the meaning of that in this particular case is to maintain a safe distance, which is defined as 2 millimeters from the ureter. Were you suggesting in your submission that the judge went further than that and said the standard required that the surgeon not injure the ureter?
I believe we said that the standard would be to identify and protect the ureter.
Okay. And was it appropriate for the judge on the issue of causation to make a determination as to what happened, what caused the injury, in this case, the instrument burning the ureter?
I will answer your question, but I also just would like to note my co-counsel will go more in depth regarding that topic, but okay. I just a quick answer to that question is the breach of the standard of care, the breach has to be identified before we can even move on to causation. Because if there was no breach, then that means that Dr. Ward did in fact take all the steps that were necessary that a reasonable surgeon in his position would have taken. And that means that regardless of the fact that an injury occurred, Dr. Ward wasn't negligent because he did take those reasonable steps to avoid the injury. The surgery involved a common and known risk, and Miss Armstrong was aware of the risk, and Dr. Ward took the necessary steps to identify and protect the ureter. The standard of care was met despite the injury to the ureter. The trial judge explicitly stated, quote, "I am satisfied that the standard of care for a general surgeon is to identify, protect, and avoid direct contact with or close proximity to the ureter." Dr. Ward took the steps to identify and protect the ureter, and the trial judge accepted Dr. Ward's testimony that he always kept 5 centimeters away from the ureter, and I've noted this in paragraph 21 of my factum. Dr. Hagen stated, quote, "A surgeon has only successfully protected the ureter when it is not in direct view of the camera. Dr. Ward correctly pushed the ureter out of the camera's view and therefore protected the ureter. Dr. Ward took the necessary steps to identify and protect the ureter. A resulting injury is not a breach of the standard of care. By focusing on the result of the surgery, the trial judge's analysis was expecting a standard of perfection rather than a standard of the reasonable person. The trial judge held Dr. Ward to a standard of the goal that a prudent surgeon would have when conducting the operation, rather than the means that a prudent surgeon would use to attain that goal. Based on the facts given by my friends' own experts, coming within 1 to 2 millimeters of the ureter automatically causes injury. Using that logic, staying 1 to 2 millimeters away from the ureter is not a step, it's the goal. Defining the standard of care as the absence of injury neglects to acknowledge the steps that need to be taken to achieve that goal and the other duties required by the surgeon in the process. Defining the standard of care as the absence of injury implies that any surgery that causes injury has breached the standard of care. With every injury, the standard would be breached. Additionally, a surgeon who does not cause injury has met the standard of care automatically. The emphasis is placed on the outcome rather than the means, and instead, the focus should be on the steps that were taken during the process. The standard of care should be to identify and protect the ureter, and the trial judge was satisfied that Dr. Ward did so. And now my next point is that the Court of Appeal applied the correct standard of review. The Court of Appeal correctly identified the error of law by part of the trial judge in his definition of the standard of care and reviewed this error on a standard of correctness. Justice Pachoco in the Ontario Court of Appeal stated that by defining the standard of care as the avoidance of injury, an absolute standard is imposed since liability follows with every injury. This definition results in circular reasoning. The failure to meet the standard of care causes injury because causing injury is a breach of the standard of care. Therefore, it is generally an error of law to define the standard of care using outcomes or goals. An appeal court is not meant to question facts, but rather assess the application of the law. Whether Dr. Ward correctly identified and protected the ureter are not questions before this court. These findings of facts were determined by the trial judge, who accepted that these steps were taken by Dr. Ward to identify and protect the ureter. The question is whether these steps that were taken were enough to satisfy the standard, despite the result of an injury. I will now direct the argument to my co-counsel, subject to any questions that you may have.
Good morning, Justices of the Court. Firstly, I will address why in our submission, Dr. Hagen's testimony should be favored over Dr. Bernstein's. The expert evidence from Dr. Hagen showed that Dr. Ward met the standard of care. The standard of care, as established by Dr. Hagen, was to take reasonable steps to avoid contact or close proximity to the ureter. Based on the facts of this case, it's uncontested, according to Dr. Hagen's testimony, that Dr. Ward took such reasonable steps as identifying the ureter, pushing it out of the way, and continuing to reconfirm its location out of the way of the ligature. Dr. Hagen has claimed to complete the same procedure, a laparoscopic colectomy, approximately 60 times per year, using the ligature device, quote, thousands of times. Dr. Bernstein's a general surgeon who has performed weekly colectomies for the past 30 years. However, he does not do this procedure laparoscopically and is not as well versed in using the ligature device. It was only from Dr. Bernstein's testimony that it was believed that coming within 2 millimeters of the ureter with the ligature device is said to have breached the standard of care. Nevertheless, Dr. Bernstein's evaluation of the standard of care was favored in place of Dr. Hagen's, even though Dr. Bernstein testified that, quote, Dr. Hagen would be in a better position than me to talk about how a laparoscopic surgeon achieves the goal. Although an uncommon occurrence, Dr. Hagen explains that a ureteric injury is a known risk of the operation and is satisfied that Dr. Ward took these steps to avoid such injury.
Sorry, counsel. So are you suggesting that we now, as the Walker Supreme Court, essentially play a weighing game between the trial judge's expert evidence and that we now take a step of correctness? Or should we not show deference to the trial judge's findings, and particularly finding one expert's opinion more credible than the other?
I'm not particularly saying that. My point in making this argument is to say that the standard of care as defined by the trial judge is only based on the evidence from Dr. Bernstein and not considered what Dr. Hagen says that Dr. Ward took such steps to identify and to protect the ureter. And for those two steps to be, pushed aside and to have the main focus of the standard of care be on this 1 to 2 millimeters, which which Veronica said is on our submission is synonymous with injury, is holding the doctor to the standard of perfection. And instead of I don't know, acknowledging all of these steps, you're only focusing on the outcome of the surgery. Does that answer your question? In Dr. Bernstein's testimony, he stressed the significance of re-identifying the ureter continually throughout the surgery, which was a step shown to be completed by Dr. Ward. He stated that the risk of injury in a routine colectomy surgery without any abnormalities of the colon should be, quote, 0. The trial judge dismissed this assessment of risk as this is a personal opinion not backed up by evidence, as noted in the trial judge decision. However, he agreed with the evaluation of the breach in standard of care. All doctors agree, as in our submission and in opposing counsel's submission, that there were no abnormalities in the surgery in the appellant that would make her more susceptible to injury. Dr. Ward was clear on the instructions to identify and to protect the ureter before proceeding with the colon removal, and to continuously do so throughout the procedure. Dr. Ward has claimed to perform—
Counsel, my apologies.
Yeah,
If it is your position that the evidence supported a finding that there were no abnormalities in anatomy to render this patient susceptible to injury, then how do you explain how this injury occurred?
Well, it's our submission that there was no breach in the standard of care. I'm about to talk about this in my next point, but the causation analysis is not necessary. There's nothing in the facts or the expert evidence to suggest that this is even the fault of Dr. Ward other than the injury itself. And as opposing counsel says, the causation can only be inferred circumstantially. And we don't believe that that is evidence enough in itself to say that Dr. Ward is liable for negligence when there's no additional evidence. And I'll speak about non-negligent causes in a later point, but those were not ruled out. It's not our burden to create alternative reasoning in my submission to explain why this injury occurred. We are removing the responsibility from Dr. Ward, which is shown through his submission of staying 5 centimeters away, which leads me to my second argument of differentiating causation and standard of care. In the trial decision, standard of care was considered in relation to the injury, preventing an independent analysis. The trial judge found that the standard of care is breached when the ligature comes within 1 to 2 millimeters, which is inconsistent with the definition of the standard of care, which speaks to the process of avoiding injury, which, as we've said, is the reasonable and prudent surgeon. Causation analysis is not necessary if there is no breach in the standard of care. Both the causation analysis and the standard of care are considered under the same heading in the trial decision, which causes this problematic overlap. The standard of care asks what a reasonable, prudent behavior can be expected of a surgeon carrying out a colectomy in order to avoid injury to the ureter. The trial judge conflated these two. The appeal judge says where the nature of the injury is relevant to what happened, it's not an error to consider that injury in resolving whether the standard of care has been breached. However, since the trial judge misconceived the standard of care, he had to resolve what happened. Had the trial judge properly assessed the standard of care, it would not be necessary to conflate the two. Causation does not need to be assessed unless we identify what the breach in standard of care is. And only once this breach is identified do we move on to causation. Since there's no breach in the standard of care, we do not need to move on to causation. However, even if there was a breach, the opposing side did not rule out non-negligence. It's a general rule of law to not define the standard of care in terms of injury. There are cases where negligence alone can prevent a goal from being achieved, and in my submission, this is not one of those, which leads me into non-negligent causes. If the injury is determined to be caused by negligence alone, the judge must consider and rule out any non-negligent causes. The burden is on the plaintiff to establish that negligence is the only reason to have caused such injury.
Counsel, sorry to interrupt. I appreciate you might be running out of time, but
right.
your friend's position is that in this circumstance, it's not essentially fair for the plaintiff to have to rule out non-negligent causes because in the circumstances, she's anesthetized and is not aware of what is going on. The only person who is aware of what is going on is your client. So what is your answer to that?
Yes, exactly. And I believe it was you that pointed out Miss Armstrong has retained professionals that have the ability to determine these other negligent causes. But also, we are not advancing this claim. We are not advancing that there was even a breach in the standard of care. So to place this burden on us to rule out these non-negligent causes is not in our submission, not even our argument. So this analysis of non-negligence, we're basically saying that even if you don't accept our determination of what the standard of care is and that it has been met, even if you do not accept that, to move on to non-negligent causes and to place that burden on Dr. Ward does not seem, in my submission, fair nor even correct, respectfully. But yes, Justice.
If I may, did her experts, as you say, she had the benefit of experts, did they not say that the cause in this case was thermal injury caused by the instrument, and that in their opinion, there was no other cause, no other aberrant anatomy, no other cause?
I believe their expert was Dr. Bernstein. And in his submission, he used this coming within 1 to 2 millimeters automatically causes this this injury. However, sorry, do you mind just repeating your question one more time? I lost my train of thought.
They stated was, did her experts not present a theory of causation, namely that it was the instrument that caused this injury, and that there was not another cause to the injury?
I believe I'm not exactly clear on what Dr. Bernstein said regarding that, but I don't think it was settled that the only possible way to get this injury is with coming in within 1 to 2 millimeters. And that wasn't even proven. The only proven thing we have is the injury itself. And in my submission, that's not enough to say that there was a breach in the standard of care. If that answers your question. Also, this is a case where the standard of care is said to have automatically been breached by coming within 1 to 2 millimeters, and the trial judge rules that this is purely done out of negligence and fails to consider the alternatives. In doing so, the trial judge is insinuating that in every case and every circumstance that an accused comes within 1 to 2 millimeters, they have done so negligently and will be held liable. And then I'm just going to move on to my closing statements here, subject to any questions. Surgeons cannot guarantee outcomes. Unfortunately, many surgeries yield tragic results, and a surgeon should not be automatically deemed negligent because the patient was injured. Rather, a surgeon is obliged to take certain steps or precautions to avoid injury. If those steps are taken and an injury still occurs, the surgeon cannot be held liable for negligence. This is a case about a surgeon who performed a routine surgery and was aware of and followed the necessary steps, yet the result was unfavorable. Causation need not be assessed unless there is an evident breach in the standard of care. We cannot ask for perfection from professionals. Instead, we can ask them to take reasonable steps to avoid injury. In our submission, there is no evidence that Dr. Ward breached the standard of care, therefore causing an injury does not hold him liable for negligence. And thank you.
The court now invites counsel for the appellants to begin their optional 3-minute rebuttal.
And sorry, quick question here. Can we divide the rebuttal between myself and the co-counsel, or one of us has to assume the whole rebuttal? One of us. Okay.
No, 3 minutes, so you can.
We can divide it 1.5 minutes each.
Yes, go ahead.
It's okay. I'm just gonna go ahead. Okay.
Yes, go ahead. You can
Okay,
divide it
okay.
into 2 if you want.
Okay, thank you so much. I just wanted to point out a few things that were raised from the information that was just provided that just, I don't believe, aligned well with the evidence that we had. So I believe that it was mentioned that Dr. Ward had suggested that ureteral injuries are a normal complication of colectomies, but our trial evidence actually indicated the opposite. It seemed as if the minimum standard that most of our expert witnesses had mentioned was not only the duty was to identify and protect the ureter, but actually avoiding it. So I just want to also go into a bit more detail about the ligature tool itself. The ligature tool is widely known to be an instrument that increases in extreme amounts of heat. It like sends electrical currents. It can cause burns within close proximity to tissue. And we do know that, in fact, Miss Armstrong's colon was in healthy condition prior to the surgery, and there was no abnormalities. However, after the surgical process, she suddenly sustains a burn. The expert evidence did, in fact, show that the only possible cause of the injury would have been coming within 1 to 2 millimeters of the ureter. And as my friends did mention, the camera was not in complete view the whole time, which may have been a necessary part of the surgery. But at the end of the day, without this videographic evidence, it puts individuals like Miss Armstrong in a position where they have to use circumstantial evidence to infer what happened. I'd like to submit that information as my rebuttal. And if my co-counsel has any further contributions.
Okay. This concludes the matter of Armstrong versus Ward.